Good morning, everybody, at the College of Europe Natolin campus. It's my pleasure and honor to welcome all of you at the conference organized by the Belgian Embassy with the College of Europe. For the college, for our students, that's also an occasion to take part in the conference, and I would like to thank you, Ambassador, for such a possibility to host this conference. At the College of Europe, I would like to welcome ambassadors who decided to come and to take part, our students, but also the students from Erasmus, from the University of Warsaw. I would like to wish all of you good discussions, constructive conclusions, and treat the place as a home for these hours you will spend here. Once again, thank you very much for your coming, and good luck, good discussions during your conference. Thank you very much.
Pani Rektorze, dear colleagues, distinguished members of the panel, dear guests. First of all, thanks a lot, Pani Rektorze, for hosting this conference. I can testify to the audience that the Embassy of Belgium and the College of Europe Natolin campus are, let's say, are engaged in a very close relationship, and this conference is one of the examples, and as a matter of fact, the first in a series since my arrival in Poland. We organized this conference today on the occasion of the 20th anniversary of the signature of the Treaty of Rome establishing the International Criminal Court. International Criminal Court, that is, and the Treaty of Rome, that is a landmark in the fight against impunity. And by impunity, we mean, of course, in this context, the serious violations of human rights and international humanitarian law. The fight against impunity is one of the priorities of Belgian foreign policy, as recalled by our Minister of Foreign Affairs, Mr. Reinders, before the Belgian Parliament last month in presenting his policy priorities for the year to come. Over the years, Belgium has been an important actor on the international and national scenes. Internationally, Belgium has supported the establishment of the International Criminal Court and other international criminal tribunals. In this regard, our country has been closely involved in the drafting process of the Rome Statute. Since the establishment of the International Criminal Court, Belgium has remained extremely active in providing technical and political support to the court, and this through a close cooperation. No later than last year, the Assembly of State Parties to the Rome Statute adopted 3 new amendments to the definition of war crimes, and those amendments were initiated by Belgium. Nationally, Belgium has very early on adopted a law enabling the prosecution of international crimes perpetrated outside its borders. This law made, for instance, the prosecution, the trial, and the conviction possible of Rwandese genocidaires in 2001, 2005, 2007, 2009, and more recently in 2016. As from next year, Belgium will sit as a non-permanent member in the Security Council. Our minister has already announced that the fight against impunity will be one of the topics at the heart of our preoccupations during all the debates at the Council. Dear guests, I look very much forward to the presentations today by distinguished members of the panel. Many of of them coming from Belgian practitioners in the field of international law, international humanitarian law, and especially very much knowledgeable about today's topic, about the fight against impunity. I look forward to the different points that will be covered, and we have been very careful. And what am I saying? Anne-Sophie Massa, who is my collaborator at the embassy, who is the mastermind behind this conference. Anne-Sophie has really looked to the fact that you would have the broader spectrum possible of the different topics that have to do with the fight against impunity, and in that regard I also especially mention, for example, victims' rights, and also the cooperation and complementarity between international tribunals and the national tribunals, because the fight against impunity is not only about international institutions and international courts and tribunals. It is the, let's say, the utmost priority task for all members of the international community. So without much further ado, I would like to leave the floor open now for debate, thanking again the College of Europe for its hospitality, for the very efficient assistance in organizing this conference, and wishing all of you very fruitful debates. Thanks a lot. Dziękuję bardzo.
Excellencies, dear guests, this is my pleasure to play the role of the moderator of this conference today. Let me introduce our first panelist this morning, Professor Elzbieta Cuza. She is the director of the NOHA, the Consortium of European Universities conducting programs in humanitarian action at the University of Warsaw. She is also the director of Master's Studies on Humanitarian Action and the director of Postgraduate Studies on Humanitarian Aid. She works at the Faculty of Law and Administration of the University of Warsaw, and she is a visiting professor at the College of Europe in Natolin. She has been for more than 30 years a volunteer with the Polish Red Cross, and she is also a member of international institutions such as the International Humanitarian Fact-Finding Commission based in Switzerland and the International Institute of Humanitarian Law based in Italy. Professor Mukesh Cuza, you have the floor.
Thank you so much. I'm not sure whether I should use micro, yes. First, Madam Rector, Excellencies, ladies and gentlemen, I would like to thank you very much for this honor and privilege that you made me by inviting to speak during this very, very important event on a very topical issue for the whole international community nowadays, which is the fight against impunity. I'm invited because I'm not a practitioner in this field. I'm a practitioner in other fields, yes, that were kindly mentioned. So my role is to introduce you to the development of the idea of this fight against impunity. But actually, it's not the first time that it is addressed here at the College of Europe, because every year in spring we do organize here, I'm in the College of Europe together with the International Committee of the Red Cross, seminars on international humanitarian law, and they are organized in the framework of Master of Arts in European Interdisciplinary Studies. So if some students of the college would be interested, yes, they are. There is this option, this possibility in March 2019 to attend this seminar. And yes, so the question of individual responsibility, accountability is also discussed during the seminars. And I remember still, the event that took place 3 years ago, exactly in this room, a very nice ceremony of awarding the Bronisław Geremek Prize. The Bronisław Geremek was one of Godfathers, famous Polish politician and historian, Godfathers of this Natolin campus of the College of Europe. And yes, and 3 years ago, the prize went to Professor Mark Lewis for the book, The Birth of the New Justice, the Internationalization of Crime and Punishment, 1919-1950. And why I'm mentioning it, is that because I was a reviewer of this book, and I strongly recommended it to the jury, so that exactly this book should be awarded the prize from among many, many other that were, candidates. So, so it's not the first time, but definitely extremely important event and extremely important occasion to reflect on this fight against impunity, whether we are successful in it or not that necessarily. And again, thank you for being able to take part in this. Well, as there are not only experts in the room, but also a few students, then please excuse me for a few very basic remarks. But anyway, my role is just to set the scene, yes. So what we are discussing here is something that we call international criminal law, which is the separate branch of public international law, but a very specific branch, yes, because it's like the mixture, the combination of public international law institutions and domestic institutions. So it's about individual responsibility, individual accountability for international crimes, yes? It's not about states' responsibility. We are not going to discuss about states, and actually public international law does not know the notion of a crime committed by states. There were attempts at introducing such a concept to public international law, but it was not accepted by states. So it's about individual criminal responsibility, which according to main today's documents of public international law should be born first and above all before national courts. So every state is responsible to punish perpetrators of not only of domestic crimes, but also of international crimes, independently on whether they are crimes under domestic laws. And if this is not successful, as the Rome Statute of the International Criminal Court calls it, if states are not willing or able, then those international mechanisms should be at place. I mean, with some exceptions, yes, but basically this is the idea, and that's why today's panel is about national scenes and international scenes, yes, so international framework and international framework. With regard, after those general, let's say, remarks, few words about the history. The title of my intervention suggests that international criminal law started in Nuremberg, yes, in 1945. The title of the book by Mark Lewis suggests that it started in 1919 with the Treaty of Versailles and systematic approach to individual criminal responsibility. But actually it started much earlier, yes. I mean, there were cases already in the 15th century that the tribunals set up by the Holy Roman Empire were bringing to justice perpetrators of atrocities against the population of occupied or encircled cities. So, so actually the idea that individual should be prosecuted for crimes committed particularly during armed conflicts at the time is not very new. It's not something that was invented in the 20th century. And actually already then, the concept of common responsibility was developed, 500 years ago. Then we had more examples like during, for instance, the American Civil War, when people were executed for mistreatment of detainees but actually, when we think about systematic approach to the question of impunity, serious thinking about system, creating a system enabling us to punish individuals who commit international crimes, then it came really with the Treaty of Versailles after the First World War. So first, there was an idea of bringing the main commander, yes, Kaiser Wilhelm II Hohenzollern, to the special tribunal, which did not materialize. He was to be brought, I wrote it, for a supreme offense against international morality and the sanctity of treaties, as it was formulated in Article 227 of the Treaty of Versailles. And then there was also the idea of bringing other, less important, but still perpetrators of war crimes before courts, and this materialized, but in a very unsatisfactory way, in something that we called Leipzig farce, because out of 900 people who were indicted, only 6 were really punished, sentenced before the German court in Leipzig, and it handed down very light verdicts. I mean, the worst one was 4 years of imprisonment. So then there were a few other attempts, for instance, in the context of crimes committed by the Ottoman Empire, the famous Armenian genocide. Yes, so it was addressed in the treaties that were concluded with Ottoman Empire in Sèvres, then in Lausanne, but again, it didn't bring any satisfactory solution. Same about other attempts that were undertaken under the League of Nations auspices in other contexts. So everything that was let's say that the international community worked upon, I mean, did not yield any concrete results before the Second World War. So the world entered into the Second World War without concrete mechanisms, concrete institutions that would ensure the lack of impunity of those who would commit crimes during this war. And the scale of atrocities that were committed during the war, of course, led to the idea that the political redress, like the one after the First World War, would not be sufficient, and that something has to be done at least against the highest-ranking Nazi and Imperial Japanese officials, that they should be brought to justice. If we would have more time, the history of negotiations is really fascinating, yes, that led to the setting up of the very first tribunal, ad hoc tribunal, but tribunal, international tribunal, but of course, due to the time shortage, I'm not going to go into this. All those negotiations ended with the conclusion of the so-called London Agreement by 4 big powers, yes, USA, the Soviet Union, United Kingdom, and France. And the charter of the International Military Tribunal was annexed to this London Agreement, and then it served as a basis for all further work on development of international criminal law. The tribunal was competent prosecute for 3 types of crimes, yes, crimes against peace, war crimes, and crimes against humanity. No genocide at that time. Yes, the notion of genocide, the concept of genocide, was born later, and actually, yes, this year we also celebrate the 70th anniversary of the adoption of the first treaty on genocide, and next week at the University of Warsaw there will be a special conference commemorating the adoption of the treaty, so all of you are invited, Monday, Tuesday, Wednesday. There were 4 judges, that were nominated by the parties to the London Agreement, and as for the results, you have the statistics. Yes, so there were 24 people who were indicted. Actually, those who were present were 22. 3 were acquitted. Yes, so it was not. It was really fair trial despite all the controversies. Yes, in the sense that 3 persons were acquitted. There were those who were sentenced to death, and then a few others to imprisonment. Also, criminal groups and organizations like Gestapo, like SS, were also condemned. And then those, after this 1 year, more than 20 people sentenced, but actually many more were tried later on, either in the American occupied zone in Germany, or just by national courts. For instance, in Poland we had the Supreme National Court that was dealing with those after Second World War cases for many years. A very similar tribunal was established in Tokyo, so we say Nuremberg, but actually Nuremberg, Tokyo, like 2 sister tribunals, although there were some differences. For instance, the legal basis, yes. The tribunal was not established by the international treaty, but just by the military order of the Supreme Commander in the Far East, who got this power during the international conference a few months earlier in December 1945. This tribunal worked slightly longer, not less than 1 year, but more than 2 years. Same crimes as in case of Nuremberg Tribunal. More judges, because more states were involved in the hostilities in the Far East. So we had 11 judges. Again, the results. More than 20 people accused, and different types of sentences. No one acquitted. No criminal groups and organizations were tried at this occasion. So these were the small differences between those 2 tribunals, but basically we call them sister tribunals. Yes, and there were many controversies regarding those tribunals. I'm sure you heard, even not those who are not experts in international criminal law, that we speak about victors' justice in this context. Yes, those who won the war, they were prosecuting those who lost this war, that the crimes committed by allies were completely not discussed by those tribunals, were not falling under their competence. That actually may be the principles about, regarding impossibility of prosecution for crimes that were not crimes at the moment of punishment. Yes, norum crimen sine lege was violated because there were controversy about the status, for instance, whether crime against peace was really a crime. After Nuremberg and Tokyo, we had attempts again to establish a permanent criminal court. Yes, it was the work carried out under the UN auspices. The International Law Commission first did something that, which is the subsidiary body of the General Assembly, to codify and develop international law. First did something that was successful, namely it codified the so-called Nuremberg principles, which really laid the foundations of today's international criminal law. But then, it completely failed. Yes, it was tasked with drafting the Code of Offenses against the peace and security of mankind, including the establishment of a permanent international criminal court, and it spent many decades on discussing it, and actually, finally, this work was accelerated only in the 1990s, when we had already further developments that made it absolutely imperative to have finally a permanent international tribunal established, because we had so many international crimes committed after Nuremberg and Tokyo that were completely went unpunished because of the lack of will by states concerned and lack of international instruments. So finally the breakthrough came with very tragic events at the beginning of the 1990s, namely the horrors of the war in the former Yugoslavia, particularly in Bosnia and Herzegovina, 1992-1995, with the most horrifying atrocities committed during this conflict, and the genocide in Rwanda. So those types of atrocities really shake the international community. But again, international community didn't possess a permanent mechanism, so what was able to do was just the creation of new ad hoc tribunals, yes, the so-called ICTY for the former Yugoslavia that was located in The Hague and was established in 1993 and closed a year ago, and for Rwanda that was based in Arusha and in Tanzania and closed established in 1994, very soon after the genocide, and closed 3 years ago in 2015. As both tribunals are closed, they are now replaced, but not all the cases were closed. So we have the International Residual Mechanism for Criminal Tribunals in The Hague. So again, here we again speak about sister tribunals, yes, because they were established more or less at the same time in the history. Again, both ad hoc, what was very controversial, set up by the Security Council, not by international agreements, but by the Security Council as Security Council subsidiary bodies, and they were really sister tribunals because of also some common organs and institutions. As for the key figures, these are the results of the work of both tribunals. It was extremely important that they were established, and despite all the controversies regarding their effectiveness, costs of their functioning, etc., I mean, it was extremely important for the international community to have them. As I mentioned, the last minute, I know. As I mentioned that in the meantime, the work in order to establish the permanent tribunal was very slow, and it was impossible to predict whether it will really bring anything concrete. So we have the proliferation of different ad hoc tribunals, hybrid tribunals, for different types of conflicts, sometimes mixed, established jointly by a given state and the United Nations. So particularly worth mentioning is Special Court for Sierra Leone, the decisions by this court, particularly in the case of Charles Taylor, the acting president that was convicted, yes, that was prosecuted by this court, was extremely important. So few other examples. But anyway, at a certain point in time, particularly with Rwandan tribunal and Yugoslav tribunal being established, and all those interpretations regarding their establishments being in place, this prompted the international community to succeed in the creation of the permanent international criminal tribunal. Yes, 24 years ago. on the basis of the draft prepared by the International Law Commission, with the huge support of the civil society, international civil society. There was a huge coalition of states and international organizations and non-governmental organizations created in order to support this initiative. So this whole effort of many different actors led to the creation of the tribunal. The Rome Statute was adopted in 1998, and with 60th ratification in 2002, the statute entered into force. As Ambassador of Belgium mentioned, it was amended also later on. We have 124 states parties, but this figure is not stable. Yes, there are new states that are acceding to this instrument. There are states that are withdrawing. That are states that are withdrawing, considering the tribunal to be a bit too political, too politicized. So there are many controversies regarding the functioning of the tribunal. I'm sure that my, co-panelists and speakers today will address it as well. To the list of known of those crimes that were already prosecuted under earlier documents, we had genocide added. As for the figures, it's yeah, of course, it's not. Statistics are very, let's say, confusing because of the dynamic changes that take place in the tribunal. What is extremely important with this politicization is that under investigation, we have 11 right now. Yes, we have 11 cases, 10 of them from Africa. But in the preliminary examinations, we have many other cases from other regions of the world. This is to show that the accusations by African states that say it was created against Africa, Africa is the main client, is not that justified, because actually quite a few African cases were referred by the African governments themselves. Yes, they were not taken proprio motu by the prosecutor, or they were not addressed by the UN Security Council, but they were referred by African states themselves. So, well, but we have to face the fact that international justice will be always politicized. We had controversies around Nuremberg and Tokyo. We had controversies around Rwanda and Yugoslavia. We have and will have controversies around the International Criminal Court. But it doesn't mean that we have to stop our fight against impunity, both on national and international scenes. And this is the message that I pass to my co-speakers, who will address those issues more in detail. Yes, thank you so much, and sorry for exceeding my time.
Thank you, Professor Mukesh Cuza, for your presentation on presenting the roots of the fight against impunity in history, which I think very well set the frame for this morning's conversation. So now I will give the floor to the next panelist, Mrs. Wenke Rochen. She's a public prosecutor since 1995, first at the Prosecution Office of Brussels, where she worked more than 10 years on serious and organized crimes, and since 2013 at the Federal Prosecution Service in Belgium. The first 5 years she was dealing with terrorism cases, and since 2018 she's working on violations of international criminal law. Mrs. Rochen, you have the floor.
Thank you very much. I also would like to thank you, first of all, for the invitation to come and speak here in front of you. And as Dr. Mukesh Cuza said, there's a national and an international framework to fight against impunity. I am testifying here for the national framework. So I'm a federal prosecutor at the Federal Prosecution Office of Belgium, situated in Brussels. it is a prosecution office that has a national competence. We exist since 2002. And so normally in Belgium there are 14 local prosecution offices, with so at each time a head of prosecution in lead. And so there are 14 local, and when you go into appeal, there are 5 prosecution offices in appeal, and the federal prosecution office goes next to it. So we treat a case from the beginning until the end, in first instance and in degree of appeal. And we are competent for whole of the territory and not as a local prosecution office, so just for one part of the country. We have specific missions, so we work in investigation and prosecution in certain fields. So there's in terrorism, we deal with every terrorism case in Belgium, but also organized crime that we take from a local prosecution office. When it goes really abroad or all over Belgium, we take it onto the level of the federal prosecution office. There's acts of piracy, so there are not so many pirates anymore, but there was a time that it was otherwise. Arms and human trafficking, so there again, when it goes abroad we take it over. Offenses committed by Belgian soldiers during missions abroad, that's exclusively for the Federal Prosecution Office. And the serious violations of international humanitarian law, that also is an exclusive competence. So when we have files about this in this field, it is always treated at the Federal Prosecution Office. Which I go too quickly. We have some other missions because in 2002 we have been created for mainly 3 reasons. It was to more coordinate the files all over Belgium, to have more specialization, and also to have some control on police services. And so our other missions are the coordination in the action of local prosecutors, a facilitation of international cooperation, supervision of police services, supervision in the application of special investigation techniques, so that all over Belgium we work in the same way with surveillance and infiltration and so on. And also the uniform fight against terrorism. And that is an organogram from how we are organized. We are 33 prosecutors at the Federal Prosecution Office. There's one chief, the federal prosecutors, that is Frederik van Leeuw, and there are 32 federal magistrates. There are 16 Dutch-speaking and 16 French-speaking, as it goes in Belgium. And then we are divided in 4 sections. There's a terrorism section, there's an organized crime section, a support section, in fact, so the international cooperation and particular missions. And then at last there's an international humanitarian law and military competences section. So as you see, we are 4 magistrates to work in it, the head of the section, and 3 people dealing with the files, 3 prosecutors dealing with the files. There are 2 French-speaking, and there's me. But next to the international humanitarian law, I also have a lot of files against military people. And since this year also we try to work on international corruption, because it's rather difficult to so how was the legislation in Belgium? It was only in '93 that in Belgium we had our first law on this, related to the repression of grave breaches of international humanitarian law, and it was limited to war crimes. So there was no genocide and there was no crimes against humanity. We had a universal jurisdiction, so we were competent for everything all over the world. In 1999, there was a change to that law of 93, so there was the introduction of crimes of genocide and crimes against humanity. And there was added that there was no immunity, so we really were competent for any case against anybody all over the world. It was, I still think it's a good idea in theory, but in practical it was not workable, because it was quite difficult to treat some complaints, because there were complaints addressed so to Belgium about presidents still in function, and it put Belgium in a rather difficult situation sometimes. I remember that the one who was dealing with those cases had a lot of discussions and on political level, so how to deal with some cases. And then in 2002, Belgium was convicted by the International Court of Justice, because there was an investigating judge who had issued an international arrest warrant against a a minister of foreign affairs still in function. And so there was said that is not possible. And so in 2003, we had a change of law that introduced the war crimes, crimes of genocide, and crimes against humanity into our Belgian criminal code, but who limited also our universal jurisdiction, so we have to have a link with Belgium. So when offenses are committed in Belgium, the link is very clear, but in general it concerns perpetrators, so supposed perpetrators of crimes that are living in Belgium or that have a Belgian nationality. Or victims that are living in Belgium or that have a Belgian nationality. And that law also stated that there's an exclusive competence for the Federal Prosecution Office for that kind of crimes. There was also immunity that was introduced. I didn't put it on it. No. So immunity was introduced for the, as it goes on an international level, so for presidents, ministers of foreign affairs, and head of governments in function, so they can't be prosecuted. Where am I? Here. So what are the actors, who are the actors who are working on international humanitarian law in Belgium? So there's, first of all, Federal Prosecution Office. We always work, we try to always work with the same unit of the Federal Judicial Police. It's a unit of the Federal Judicial Police in Brussels who is specialized mainly in the Rwanda cases. But as there is a bit of lack of capacity, we also work with other federal police officers. So I have a case that is going on in Ghent, and I work there with the federal police situated in Ghent. So they are now in between, more or less specialized in their file. We have no specialized investigating judges. But there again, for the files going on in Brussels, we try to work always with the same investigating judge, so that they are de facto experienced in the field. We have no specialized trial judges. And there again, I think that the president of court tries to give it more or less at the same people, but there, once again, the latest trials, we only had 4 convictions in Belgium in international humanitarian law, and that were cases of 2001, 2005, 7, and 9. So, and then there's the Court of Assize, whenever we have to do with grave breaches of international humanitarian law. In Belgium, those files have to come before the Court of Assize. So where we work not only with professional judges, but with jurors. People that are in normally life, they are a teacher, or they are baking bread, or they work in a bank, and then suddenly they find themselves into court to listen to a case of Rwanda genocide. So I don't have to explain you that it is rather difficult that we have first to give them a history lesson. So there are a lot of testimonies from professors, from people from over there. So we first have to bring Belgian people living in 2018 back to 94, Rwanda, where they most of the time never have been, and to explain them what happened there before we can start with explaining what the person that we put in front of the court, that we suppose that he did. So it is quite extraordinary to work in. Let me go further on the numbers. We have in Belgium at this moment 117 files going on. So there are 41 preparatory inquiries, so they are led by the prosecution, federal prosecutors, and there are 76 investigations going on. So they are at the level of the investigating judge, but nearly followed by the federal prosecution office. So of those 117 files, most of them concern Rwanda, so 44 of them are related to Rwanda, and 73 concern all kinds of other countries. So we have Guatemala, we have Cambodia, Sierra Leone, Congo Brazzaville, Democratic Republic of Congo, Ivory Coast, Chad, Israel, Syria, Iraq, ex-Yugoslavia. So it's a very broad range of countries. And as I said, we up to now have only 4 trials by jury for international humanitarian law. So, and what were they about? So the Rwanda cases, they all concern the genocide of '94. How do they arrive at the Federal Prosecution Service? A lot of them concern international arrest warrants who were issued by Rwanda against people living in Belgium. Belgium doesn't extradite people to Rwanda because we don't have a cooperation convention with them, so our judiciary, we have to treat the cases ourselves. Second is a lot of also declarations done by asylum services. They have some declarations done by other people, and so they send them through to the Federal Prosecution Office to warn us that maybe there's something going on with some people living in Belgium. Then there are complaints done by towards an investigating judge about some eventual supposed perpetrators from Rwanda genocide living in Belgium, and then at least we have Belgian victims that are doing a complaint at the police services against somebody not living in Belgium. And then there we still have, as a federal prosecutor, a possibility to look into more closely into the complaint to see if it really concerns international humanitarian law and if there's a possibility to go on with it and if it really has to be treated on a Belgian level and not on an international level. When we have our hesitations, we can go with the case, with the complaint, to a pre-trial chamber that can give us right, or that can say no, go on with it, and then we treat it in Belgium. We have one Liberia case that concerns facts committed in '92, so a long time ago. by, so maybe by a woman because she's not convicted, by a woman living in Belgium. And she would have been a commander of troops over there who installed a control post in Monrovia, so in the principal city, and so everybody had to line up, and over there the most biggest atrocities happened. So people were killed, were violated, were tortured, and so she would have been a commander of the troops who were the perpetrators thereof. We have a file of Congo-Brazzaville, war crimes, crimes against humanity, that concerns mainly facts from after the war. So there was a civil war in Congo-Brazzaville. A lot of people had to flee to Democratic Republic of Congo. And when in 1999 they came back, there were a lot of people who disappeared. More than 350 people disappeared, a lot of them probably killed. And so there was a complaint against Pierre O, who was a minister of Internal Affairs at that moment, and he has a mixed nationality. He's from Congo and a Belgian nationality. We have Syria and Iraq cases. There we only have crimes against humanity. We don't prosecute for war crimes under international humanitarian law in Belgium. We prosecute them for terrorism then. And crimes against humanity, we have at this moment only 2 files, and that concerns more the Yazidi women that were taken into their houses as sex slaves. So that concerns slavery. Other cases that we had that was seemed to have been a very beautiful case, the Sierra Leone, that was against a businessman, a Belgian businessman, who would have participated in crimes against humanity, and that was more like people putting into slavery to dig out the diamonds and then to sell them. There was an international arrest warrant issued against him. He was arrested in Spain and extradited to Belgium, but he died in prison. He committed suicide. And then we had the Hissène Habré case in Chad. And there was also an international arrest warrant issued by the investigating judge. He was found located in Senegal, but Senegal didn't want to extradite him. And so Belgium went to the International Court of Justice, and Senegal has been convicted. And so they had the audience themselves. And I know that the Belgian investigating judge went to testify over there about his investigation that he had completed. And that were the 4 jury trials of Rwanda. I put it in there to show you that it really is, as was said, an individual responsibility, and all kinds of people have been prosecuted. So we had the first time we had a teacher, an ex-minister, and 2 nuns. In the procedure of 2005, we had 2 businessmen. In 2007, we had a member of the armed forces of Rwanda. In 2009, an Interahamwe leader. You see, they all have been convicted for war crimes. So there was no genocide, and that was so partially because in our Belgian legislation in '94 there was no genocide, but we tried it in the last case to introduce it based on the international custom law, but it was denied by our pre-trial chamber. The other times we didn't do it because, as I tried to explain you, it are already very difficult trials to lead as a prosecutor, and so to not confuse too much the jurors, we just limited it on war crimes that seemed to us the easiest thing to do, and so they all were convicted for the war crimes. So yeah, that's the jury trials. We work in two parts. First the awareness and then the trial phase. Yes, I put it that it were long trials, that they lasted for 2 to 4 months. But so I understand now that it is long on a Belgian level, because a trial can be much longer. But for us, yes, normally, and when we don't go into assize, I can have a big terrorism trial done on 3 weeks, and so I have 22 persons convicted. And when we go into assize with the normal assassination, then normally it takes 1 week. So 2 to 4 months. Every day it's long, and it is already very hard. So I can't imagine what it must be to be for 1 year or more in court with the trial. Perspectives for 2019. We hope to have 2 Rwanda cases before the Court of Assize next year. So they are now in the phase of being sent to the Court of Assize. It's in fact 4 cases, but we are going to join them 2 by 2. And for the first time we try to put the genocide into the file. So we had the first pre-trial chamber now followed us and sent them to Assize for genocide, but the accused went into appeal, so we will see what it gives in appeal, if we can go on. And then just at last, there's our international cooperation. That is, even if I work in the national framework, which is very important. So first, there's a cooperation with international criminal jurisdictions. There's a national law that regulates everything, so how we have to work with those jurisdictions. There's a genocide network that exists that I personally think is very interesting. It is with all people of Schengen countries, but there are quite a lot of countries that are there. They are called observing countries, but they participate as any other country. And so it's Canada, United States of America, Switzerland, and it is every 6 months, and it's 2 days. And so the first day there are quite a lot of ONGs that come and present themselves, and they tell us what they are doing into the field and what they can represent for us and how we can work with them. And then the second day it is only magistrates and police officers and people of the Ministry of Justice that remain, and then we really go into the files, and we talk about what we succeeded to obtain, where we still have problems, and then there are other countries who intervene and say, yes, we had the same problem, we tried to do it like this and like this. So it is really important to, because we all are confronted to the more or less the same genocides and the same civil wars around the world. So there's Interpol more for the cooperation on police level. Europol, where recently they started to have a database with on mainly Syria and Iraq, but also already on other genocides and serious violations of international humanitarian law, so where we can obtain information. And then there's a mutual legal assistance initiative that has been taken to have a convention with as many countries as possible to regulate the international cooperation, at least for what concerns the international humanitarian law. And Belgium is one of the motors behind it. And we see that, for example, Rwanda is not in favor of international cooperation on all the levels, but is in favor of something as for international humanitarian law, what could already be of a big help. But it is my last slide. So I timed it very well, I think. So I can thank you for your attention.
Thank you very much, Mrs. Rochen, for sharing your experience as federal prosecutor in Belgium. And so the last speaker of this first session is Marc Dubuisson. Marc Dubuisson is the current director of the Division of Judicial Services within the Registry of the International Criminal Court. Before joining the International Criminal Court, Marc was the head of the Support Services section of the International Criminal Tribunal for the former Yugoslavia. And in his previous national life, before joining the international institutions, Marc worked in different national jurisdictions in Belgium. Marc, you have the floor.
Thank you very much. First of all, I would like to thank the ambassador and yourself to have organized this event. And I would like also to thank the Rectorat, because this is a fantastic place here, and we have to be proud to be able to use such a type of facilities. Just briefly, what are the judicial support service at the International Criminal Court? And I think it's well placed because we heard today how we have created and how we arrived to the International Criminal Court, and we have seen that some countries have improved and increased the way they work. Donc, let's put ourselves 2 minutes in the courtroom of The Hague. That's the courtroom of The Hague here. Okay, if this is the courtroom, you will have here the judge, and we have 3 judges. Donc, this is a trial chamber. Okay. Then you will have on this place, the 3 first row, this will be the defense in The Hague. You will be the prosecutor. Yeah. On this side, it will be the victim. And this side, it's a bench for the state. Why do we have the bench for the state at the court? Let's start. Judicial services is the person who will sit at The Hague very close to the windows, will be the suspect or the accused. Okay, he will sit there. Donc, I'm in charge of the detention center in The Hague. Donc, all the suspect, we say suspect because until the charge has not been confirmed, they are suspect. When it's confirmed, they will be an accused. We do not have indictment as such at the court. We have charge, an arrest warrant, and then only after the confirmation we have an accused and we have a trial. I'm dealing with this person. Here we have the lawyer, the defense lawyer. Who is recruiting the defense lawyer? Who is training the defense lawyer? How they appear on a list of counsel at the court? And mainly, when the person is indigent, who is paying the lawyer? That's a section called the counsel support section, who are dealing with all these matters. And we have on top of this the Office of Public Counsel for Defense assisting the lawyer. Then we have to think about the victim. And it's good that there is a lot of young people there, because we need to get the victim. And how to get the victim is by collecting the form of participation in the field. When we go, we interact with the leader of the community, with some victim directly. And mainly it's a young legal officer who join the court, who mostly are doing this job. So it's a call, by the way, to apply at the court, huh? For the young one. So this victim, they need to be represented by, we call it legal representative of victim. That's also we call party, because we are a mix between the civil law and the common law. Donc we say party, it's the defense and the prosecutor, and at the court we call the legal representative of victim participant to the proceedings, to make a slight difference. So we have a section called the Victim Participation Reparation section, and we have also counsel, donc this legal representative, to defend these people. We are also dealing with this, and there is an Office of Public Counsel for Victims, which is also part of the support services. Then you will have here, normally, assisting the judge, the court officer, a court usher, who will assist. Donc, these are what we call the administration, the court management, which is commonly known on a national level as the secretariat or the registry. So when we say the registry at the court, it's much broader. Then you will have, normally at this stage, at this level, you will have a lot of windows there with all the interpreters. This is also the support services that I provided. We have the two working languages of the court, French and English. We have the 6th language of the UN. On top of French and English, we have, of course, the Russia, Arabia, Spanish, and Chinese. Thank you. And we have other language. In fact, in total, we have 34 languages today at the court, which is quite large. Why? Because we have maybe one of the suspects, he will speak, or accused, he will speak Lingala. The witness will come here, will speak Swahili. Then the judge is speaking French, and the prosecutor standing up here will speak English. So during the same session, we have 4 language use. Then we will need all these interpreters. For some, like the case in Sudan, these people were coming from Chad. They were using 2 types of language, the language 4 and the language Zagawa. Zagawa is not even written language. We cannot translate from Zagawa into French or English, so we need another booth. So it will be Zagawa into Arabic, Arabic into English, and then English into French. So it means that when the prosecutor takes the floor in English, the French judge, he will get what said the prosecutor 20 seconds later. Already the defense maybe will have made an objection that he still do not know what the prosecutor say. So that's why it's quite slow in the court, because of to put in place all this system. The language services, we have also the information management, the library to assist all these lawyers. We need a library. We have a library. We have also all these electronic means that you see all over the place. And quite importantly today in a court, it's the information security. We have to face hackers when we are in Afghanistan, when we are talking about Palestine, when we are talking about Georgia. We are facing a state which is extremely large and very good capacity to hack us. We need to be quite solid. That's a little bit what are the judicial services of the court. And then you have, I will say, the décor, as we say in French. Okay. Now to get the suspect or the accused, how it works, how is it working? Extremely important. What is key for the ICC? It's first cooperation. We cannot impose ourselves, like the Yugoslav Tribunal. I work in the Yugoslav Tribunal. Indictment, we have automatically arrest warrant. We send these to the NATO force in Bosnia. They will arrest the person, send the plane back to The Hague, and we start. We don't ask anyone else. The ICC is not working like this. ICC, we have to do a request of cooperation to a prosecutor here. We will first go to a focal point in Belgium, as an example, and this will be dealt with by, as you have seen, the federal prosecutor. And they will have normally to put in place, to activate the national jurisdiction to comply with the request. That's complementarity. It's first cooperation, and on top of this, complementarity. Without complementarity, it's not working. Cooperation is key. Because cooperation is key, and we have to respect the sovereignty of the state, the biggest question is, are we obliged to say yes to your request? That's what the state, of course, that's the biggest question for the state. Are we obliged to assist you? And sometimes some state, I don't want to assist you because Mr. al-Bashir is going to South Africa and they don't want to create a big problem, a diplomatic problem. Donc, the political side will say, no, 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 no. The judge will say, could you please arrest him? And that's why we need plenty of mechanisms in place to try to make it working. And that's important that we could decide what is mandatory, what is not mandatory, and what it's called voluntary contribution. And then if everybody is happy, it's a happy world, then you could make statement, declaration, and give money. That's always nice. But that's how we work. Mandatory cooperation. That's chapter 9. As I mentioned before, what is key is the implementing legislation. Look, we need, and what brings the implementing legislation very concretely? Two things. The first thing, it's linked to, if we say the person have a charge of genocide, and the country say, oh, we do not have this in our legislation. Genocide do not exist. How could, following the complementarity, how could we request a state to implement something which is not legal or which is not recognized in the country? So it's extremely important for us that all the states will have an implementing legislation to be able to so-called recognize the law of the court, of the Hague, of ICC. In the same time, it's important that on a national level, we know who will be competent to implement the decision. Donc, this will go to the Ministry of Justice, they will go to the Parquet Fédéral, they will go to this investigative judge. Oh, investigative judge, you have seen, they are not specialized. Or maybe we need to go and to organize training for these people. Donc, what we will think is maybe next year we'll organize a workshop to train the judge. Donc we will be able to identify who need this training. And donc that's why we need this implementing legislation. Alors, what are the mandatory? The mandatory is linked to the arrest. If we have an arrest warrant and we request the state is obliged to arrest and then to surrender the person. Question of admissibility cannot be discussed on a national level. This will be discussed in The Hague. It means they have to send the person. If they are not complying with the request, we are opening a door about non-cooperation. States do not like non-cooperation. And that's why we have mechanism. The first mechanism sometimes is one chamber say, we will make a statement, like the judge, of a non-cooperation, and we will send it to New York, because it was a referral from the Security Council. And like this, we will say that they have not respect this paragraph of the agreement with the United Nations. No value, in fact. State could sleep very well. But if it's something else, like the judge asking the president of the court to discuss with the bureau of the state party, and then measure is taken against the state, that's not good for the state, who will look like very badly, and then they don't like this at all. And of course, when they refuse to act, it's mainly for other reason, which is national reason. Or because we are close to an election, and then maybe this election will not be, I will say, positive for the person in charge for the time being, and then they need to be careful about how they will manage. Donc we have the case of Gbagbo against Ouattara. We have plenty of examples like this where the person which is the leader of the government do not want to leave his place, and then it's not going very well. Donc, of course, we link, of course, the capacity of the cooperation also with national event, which for the court, we cannot take this into account. We are a judicial body, we are independent, and we request the state to make the best cooperation. Arrest is key. cooperation in the reception of witness. What are we talking about reception of witnesses? As an example, for Belgium, we have witness coming from some African state. They could use normally two ways to come to The Hague, very logistically, very concretely. One is to go through Paris, and one is to go to Brussels. So, as they are obliged to appear in court, this witness, we will request Belgium to facilitate the transit through Belgium to go to The Hague. What is difficult behind this? It's the fact that some people could request asylum, and some states are extremely reluctant. Donc what they say, because of Dublin, they will say yes, but if they enter first is my country, donc we need to be clear. Donc, there will be development. Now we have Dublin 3, which say that, but it depends. It's not automatically the state where we enter first. Is the finality of the trip. Okay, donc I'm making extremely short here. Donc there is a lot of debate. Belgium, as an example, have accepted to do this without any problems. What is requested, an example by the authority, is that when this witness arrived, it's automatically taken by someone from the court. Like this, the Belgium is not dealing directly with the witness. Belgium is dealing with us, and we are dealing with the witness. Even more important, when we have a transit of an accused person or a suspect, the French, they say, fine, you could transit through Paris. We will provide an escort to the ICC delegation. We will never take the custody of the person. The ICC have the custody, we don't touch the person. To try to reduce any legal issue linked to this. Freezing of asset. Freezing of asset, by the way, because we are in Article 93, like the reception of witness, is linked mainly to investigation and prosecution. That's why also sometimes some countries say, yes, but it's investigation and prosecution. So when is the defense witness, do we still have to assist? It's still mandatory. That's some feedback we have. And as an example, in the Bemba case, all the witnesses of the prosecutor came to The Hague. Not a single witness from the defense came to The Hague. They have all testified by video link. Like this, they have not obliged to enter Holland or Belgium or France. There is the problem of the capacity maybe to have these people requesting asylum. All these questions have not been tackled. And then we find a solution by doing video link. But is it fair? Is it not fair? That's another question. Voluntary cooperation. Bilateral agreement. Bilateral agreement, it's extremely important. By the way, bilateral agreement, it's not binding. It's not because you have an agreement with the court that you are obliged. As an example, I will take one. Relocation of witnesses. We have a witness who needs relocation. It's a dirty hand witness, we call it. Someone who has done something wrong, but it's still a witness of the prosecutor. And he will not be prosecuted by ICC. So we need to find solution to protect also this dirty hand witness. So even if we have a relocation agreement with Belgium, we will prepare a file. We give the file to Belgium, and we say to Belgium, okay, because we have this agreement, are you willing to take the witness? If Belgium make an assessment and say, very difficult for us for many reasons, national reasons, Belgium could still reply to us, no, we will not be able to take this person. So it's not binding, but it will facilitate the process, the fact that we have a bilateral, and mainly it's also showing the willingness of the country. And it's extremely important for a court to have this willingness. If you look, as an example, enforcement of sentence, but I will take the interim release or the release. When you go to a country and you say to someone, I will bring you to the court. Normally there will be a proceedings in the field, which we call it Article 59. Article 59 is for the national authority to first identify the person, read all the charge to the person. He must be with a lawyer, that he must be able to understand what exactly is against him. And then he could be requested a provisional release in the country. If he requests provisional release, the judge there, they will be in touch with the judge in The Hague, and they will say to the judge, we have a provisional release. The judge in The Hague, they will say, okay, what are the motivation for the provisional release? There is 3 main reasons at the court for giving an arrest warrant. Donc the fact that he will destroy evidence, that it will influence some witnesses. There is some reason. Some country like Belgium it's 4, at the court is 3. Some other country have 7. It depends. It depends of the country, the condition. At the court, until recently, we have someone who say, yes, fine, I'm going to The Hague. When I will be in The Hague and I will request my provisional release, there is not a single country who will take the person. Is it fair also for an institution, for a model of justice? We claim to be a model of justice. If we are a model of justice, is it normal that we cannot release someone? Donc that's also a fundamental question. Donc, interim release is extremely important that we have. As an example, in the Article 70 case, we have a person, one of the accused were in France. The French legislation do not permit provisional release. So what the judge were obliged to do is to just say he is released. And then up to the registry to organize the release. And then we put it's a provisional release. Okay, that's half. Because the French say, if you say provisional release, we do not have the legal instrument to implement a provisional release. So that's why it's extremely important to go back to the implementing legislation. Relocation of witness. Why do we have to deal with relocation of witnesses? Okay, donc we have a system of protection for witnesses at the court, like it's a kind of pyramid system. You have the manual of good practice, you have what we mentioned, the investigator going to the field, making an assessment of the witness, and then we have an initial response to be able to save maybe the witness, to do an assessment. Donc mainly it's the national police. It's military people, it's a security company who will assist us to protect. And then we have relocation, which is the last avenue for protection, because that's the most disruptive one. We have what we call resettlement inside the country. If you go from Bunia to Kinshasa in Congo, it's exactly like going from Berlin to Paris. So it's already in Europa, it will be considered already as an international one. In Congo, it's a national one. Relocation of witnesses. Look, I will not be more longer on this. What is quite important is freezing of asset. Freezing of asset is extremely important for the prosecutor. Why? Because they will see if the money has been used to pay a rebel group, as an example. Or this is important for the prosecutor because maybe the benefit of an attack of a village or something has been, the result is this is on an account, so it's important for the prosecutor to be able to trace this. What we request is a legal aid. Like we give the money to the lawyer, then we heard that in fact the suspect or the accused is extremely rich. So he could pay. So could we ask also the prosecutor to use the freezing of asset to pay the legal aid or to pay the reparation? And the reparation it's a quite a big issue, this, because a lot of countries they will make the freezing of asset because it's linked to the crime. For the reparation, it's just because we need to find money to pay the reparation, to implement reparation in the field, and reparation, a broader term, the Joannet van Boven principle, that's what it's more rehabilitation. Look, this costs quite a lot of money. Could we use this freezing of asset for the purpose of reparation? Nothing to do with the crime. And that's of course an issue for the country. And this is my last slide. very clearly what is also considered positive or part of the cooperation. It's a declaration of the occasion of the 20th anniversary. Like it's a statement done by the the deputy prime minister of Belgium and the minister of foreign affairs, who reiterate all the support to the court, and it was a little bit also linked to the Bolton statement, the US statement, which was against the court. So it's always good to have high-level authority saying something regarding the support of the court. Specific support could be, as an example, Belgium provide us military airplane to the transfer of some accused. Additional financial contribution, it's example, the child soldier Belgium, the Ministry of Justice in Belgium decide to allocate some money only for the child soldier of Congo. So we have a specific program through this additional financial contribution. And then, of course, we have the contribution for the trust fund for victims. Voilà, thank you.
Thank you, Mark, for your presentation. We are running a little bit late, so I suggest that we take 5 minutes for possible questions that you would have. So please introduce yourself before asking your question. Thank you. Okay, Ambassador.
Thank you very much. According to the rule, Mr. Duboisson is giving us, the defense is asking the floor now. Well, first I want to thank Belgian organizers for addressing and tabling this topic, because coming from The Hague, also for my country, the Netherlands, this is an important topic. I would like to add one element to the discussion, and that concerns the objective of what we are doing. And here we are saying fighting impunity, but I would like to add another element, important element, and that's of course helping countries and regions to overcome their past and to start a process of reconciliation. And I would say there international judicial mechanisms play an important role. And I have some experience in former Yugoslavia during that time, so I can a bit give you some information of what's important in this respect. And I wrote it down. First of all, I think recognition of jurisdiction by the countries concerned, and they are looking at the International Criminal Court in The Hague. We have some experiences. You mentioned an obligation like ICTY that countries were obliged, but even then you could ask Mr. Bramers, one of your compatriots, even when countries are obliged, it's not ideal to say it in one sentence. On the other hand, I would also, what you mentioned, the cooperation between national judicial systems and the court systems, and even there you can see different experiences, and it's very important for the acceptance in countries that there is proper cooperation. I would say there is also a role for the mechanisms, the courts themselves, because they will always be criticized as far as the verdicts are concerned. I think quality of the procedures is very important, and what there I'm a bit critical. What I missed a bit in the past is the transparency. I know there are limits. The efforts courts are making to explain in the regions what they are doing and to defend themselves a bit. we call it in our circles public diplomacy. I think there it could be a bit strengthened, to say it mildly. So not a question, but adding this element to the discussion, because I think the objective of impunity is already more than enough reason to be active in this field. But I think also for the countries and the people concerned in the region, creating the conditions for reconciliation, I think is an important part of the work you are doing. So I wish you strength in your efforts. Thank you.
Thank you very much, Ambassador, for your contribution. Are there any other questions or remarks? No? If not, I invite you for a short coffee break.